Hello, and welcome to ChildCustodyUniversity.com, Module 4, the Mental Health Industry. This video should be listened to completely. It is not intended to be reference material. Information here can save your case, your money, and hopefully a trial. More importantly, consider reducing conflict by using an evaluation, mediation, or my direct coaching service to help resolve issues instead of going to court, hiring attorneys, or becoming bitter and spending a fortune. Put your children first. There is always a path to resolve problems if your kids are important enough to both parents. Consider using members of the mental health industry in the most productive manner possible. Could both parents and the children benefit from every family member in counseling for 12 months before litigating? 12 months of counseling could be the financial equivalent of 2 days of litigation. The benefits for the children you claim to care deeply for could be much greater. It is definitely something to consider. Become familiar with the term curriculum vitae and ensure you look at several before selecting your mental health professional. It is like a resume with much greater detail. It could make all the difference later in your legal process. Experience and education and certifications enable a greater degree of credibility. You should also be aware if your person is experienced testifying in court. This is referred to as forensics. The mental health professional finding what evidence is relevant and being able to testify in manner making it credible. Many fear cross-examination, and this could depend on the opposing counsel as well as who your attorney is. Learn what the fees are for the testimony and learn all your options early in the process. As reported in the Counseling Today article, your witness, in 2011, George Cyphers, a counselor-educator at Kent State University, and owner of a consulting business, made this statement about testifying on behalf of clients. I have learned over the years that this is a serious business because it involves a person's life. You cannot afford to hold yourself out as an expert unless you are willing to invest time and effort to prepare thoroughly for the challenge of cross-examination. Any mental health counselor who offers legal or quasi-legal advice regarding custody should be avoided. Whether they are correct or not is not the issue. It is blatant unprofessionalism and offers insight into their psychological issues that are not under control. Consider leaning toward a counselor that speaks only within their profession, but may offer referrals or may question your approach, challenging your thoughts on a legal issue. Beware of any counselor who is overly supportive because objectivity is more important. Do your self-care with your own counselor, not mental health professionals dedicated to the custody case. Ethical boundaries of mental health professionals are to be taken seriously. Many in the industry do not respect their ethics as they should. Gentle reminders preventing harm is better than a valid complaint after they have caused damage to your children's life. The Code of Ethics can be found online at the American Psychological Association's website. Know the ethics because those that are not ethical are not going to tell you they are unethical. It is your responsibility to know and act, including filing complaints if necessary. Do not become victim to an incompetent or unscrupulous mental health professional. The link to ethics will be included under the video and on the website. For psychologists, https://www.apa.org, ethics code. For counselors, https://www.counseling.org, resources, ACA Code of Ethics, PDF. The use of counselors as evaluators in a child custody case is often used as a means of working around rules of evidence. Mental health professionals are allowed to consider whatever information they think relevant without any filter that evidence offered in a trial would need to pass through. This means that you can exploit the process or beware the other party is exploiting the process. Either way, know the mental health professional quite often needs no justification in court, under oath, for their conclusions after an evaluation. Mental health professionals are generally aware of the dynamics discussed here. What you need to know is that you may be in a population considered high conflict, yes you. There is a high likelihood that at least one party in a custody dispute is a person with a high conflict personality. If not, you would not be in litigation. Your understanding of the perceptions of mental health professionals is important. They are concerned with lawsuits and complaints. The mental health professionals are dealing with high conflict personalities, and this increases the odds they will encounter lawsuits, complaints, or other problems. Due to this dynamic, greater care may be taken by professionals to mitigate damage. They may feel in greater danger if they are aware that you have inside information and are aware of their ethical standards. Be careful not to create an atmosphere of tension in the relationship. Here is a list of what they may do as a precaution, and you should understand this is simply the professional doing their job and not take it personally. 1. Counselors may document everything. 2. Define roles specifically and in writing. 3. Steer clear of legal conversations and advice. 4. Obtain consent and release forms for everything. 5. Offer realistic criticism of principle-based decisions in a legal environment. 6. Maintain extreme neutrality between parents. 7. Refrain from commenting on an unmet parent regardless of stories heard. 8. Try unsuccessfully to abstain from legal proceedings. 9. Use carefully chosen words. 10. Take time to respond after diligent thought and counsel. When a court has mental health professionals involved in their case, their job can become easier or more difficult depending on if there is a dispute among the professionals. With notice part, it is reasonable for a judge to agree with an assessment and unreasonable not to. Alternatively, when two differing professional opinions exist, the judge must choose and will justify his choice based on their testimony and credibility. In high-conflict cases, I am sure the court appreciates the professional perspective offered by counselors or psychologists. Another useful service the professionals provide is specific insight into a litigant's sincerity, progress, or mental health in general. Assume one party has a history of abuse or addiction. The court appreciates professional insight as to the current state of the issue and a prognosis. This gives the judge information to make a better decision. It is one thing for a litigant to say they have changed, and quite another to have the professional, after several sessions over several weeks, say that there is progress and a positive prognosis. It is important to note that an expert witness is different than a witness of fact. Anyone, including a mental health professional, could be a witness of fact, but an expert witness is testifying to their opinion of issues pertaining to their expertise. They should show qualifications, and the curriculum vitae should reflect this. Their opinion is only of value if their credentials and experience support their claimed value. You should understand the different roles a counselor can have and why it matters. The goal here is not to understand the intricacies of the roles, but to be able to identify one from another in legal strategy, as well as understand that when roles change or collide, the mental health provider should be properly addressing the shift. For example, a counselor who has been your family counselor should not be testifying forensically regarding custody of your children. If that happens, have the counselor testify to their ethical responsibilities and why they believe that their ethical duties cease to exist in your case. Consider having credible documentation or a credible witness to explain the flaws in their opinion and how following the ethical guidelines would have likely resulted in a different conclusion from the opposing party's counselor. Ethical rules exist to mitigate the human condition. Every person has bias, different perceptions, and understandings of events, as well as a tendency to like and dislike people. Ethics are intended to prevent these attributes from interfering with the work being done. In universities, sciences are informally divided into two categories: hard sciences and soft sciences. The hard sciences are things we can objectively see and measure, such as engineering. No matter how many people address issues in these hard sciences, the same perception is reached because numbers don't lie. A building either will withstand 100 mph winds or not. They don't guess at the solutions. The field of mental health is a soft science. There is no real way to measure the problem, the effectiveness of theoretical solutions, or isolate random events enough to know what is really going on. This is why you hear so many names of types of therapies and theories. Every therapist out there studies some books and does their best to produce solutions that fit their specific worldview. For every theory and opinion, you can find an opposing view and alternative methods of approach. Rarely, if ever, do you hear engineers arguing about their theories, because all they must do is pull out a calculator and one is measurably different than the other. Soft sciences use imperfect research studies to create their operating parameters. These studies never state that 100% of subjects recovered. They state that they tried different methods, and of them, there is a percentage difference in the recovery solutions. It is art to a degree, perhaps as much as it is science. This is important because your incompetent or corrupt mental health professional will not show you other possibilities or their possible outcomes. Here are 2 quotes from the ethics websites. I use these 2 because they are commonly ignored and very detrimental. Know your counselor's role and the goals and expect professionalism. B. If it becomes apparent that psychologists may be called on to perform potentially conflicting roles, such as family therapist and then witness for one party in divorce proceedings, psychologists take reasonable steps to clarify and modify or withdraw from roles appropriately. See also Standard 3.05C, Multiple Relationships, and 8.4b, Personal Values. Counselors are aware of and avoid imposing their own values, attitudes, beliefs, and behaviors. Counselors respect the diversity of clients, trainees, and research participants, and seek training in areas in which they are at risk of imposing their values onto clients, especially when the values are inconsistent with the client's goals or are discriminatory in nature. Mental health professionals have an area of expertise or a wheelhouse they work in. When they venture outside of this specific area of expertise in treatment, and especially when offering expert testimony, the professionals can and should be discredited. Witnesses who are asked to testify outside their area of expertise should be expected to decline and request to modify their instructions to limit their testimony to their professional role. Counselors and psychologists are running businesses, though. Any counselor can do whatever they want regardless of ethics, as the consequences of their ethics violations will likely come long after the end of your trial. Know the ethics that apply to the mental health professional in question, and be prepared to discredit them while they are on the stand if you need. Having already filed a valid complaint may offer you credibility in rebuttal, but can also cause you to appear to be causing chaos as a smokescreen. The other caveat to these non-forensic professionals is that they can be subpoenaed to court or depositions at any time, and their duty to maintain confidentiality is up to them and then the judge. Anything you have ever said to any counselor, ever, can become part of a court record. Here are some common roles and uses of mental health professionals you may encounter and legal considerations for each. Addiction, prior diagnosis, prior evaluation. This is a situation where somewhere in history, a person involved in the case has a documented history of a mental health issue. The application of this information involves case strategy. The issue of evidence is best discussed with your attorney. Know that what your attorney learns is evidence, especially if you have been served with disclosure, interrogatories, or any inquiry has been made into the topic, especially an evaluation ordered at the case. This includes any of the interactions with counselors listed in this document, as well as possibly others. Always remember that signing a document allowing access to your medical records may allow all the information to be exposed and manipulated against you. The best advice an attorney will give you is to be honest and not hide any facts, because if you are found to have hidden relevant information, the consequences for your custody case may be dire. On the other hand, dig dirt on the opposing party to create an arsenal as if you love your children. It is better to be prepared always. Custody evaluation parenting time. Evaluation. This is a forensic evaluation. Evaluation is a tool in a trial. When is a custody evaluation beneficial and when is it detrimental? This again is an attorney judgment call that involves timing, the judge's personality, the evaluator, and history of both parties, and any number of other dynamics. Look at the APA evaluation criteria and always remember that there are ethical issues you should be aware of to defend yourself against a bad report or support a favorable report. Beware of the danger zones of the evaluations. They are expensive, and once there is a decision for or against one parent, another opinion is just a few $1,000s away. There is no science or proof that evaluations are helpful or offer good solutions for a child or the parents. There is no basis for choosing between two good enough parents. There is always a reason to expect the evaluations to be slanted in favor of one over another and not objective. It is usually the person paying that receives the benefit. This evaluation can be harmful for the children because the child can feel responsibility after being interviewed by the evaluator. The parents, who are already likely resentful, have further entrenched the hatred. Counselors are intended to be a therapeutic venue and, An evaluation has no value for resolving problems beyond a recommendation on custody. Using the industry as it was intended is the best option. APA guidelines on custody evaluations will be linked below, and on the website, it can be found at https://www.apa.org. Practice. Guidelines, child custody. Remember the following tips for a custody evaluation. Do not lie. Be timely. Prepare your questions and information in writing well in advance. Clean house, healthy groceries in home, laundry done before meeting. Have your children, as well as yourself, dress nicely. Have your children's health and school records readily available. Be prepared to show knowledge of the records. Share concerns regarding another parent without negativity. Mom's drunk? No. Do it like this. Speak to DUI she received or evidence of drinking problem and your concern for the effect on your children, because you read an article that it stated the negative consequences for children of an alcoholic. Having read the article and having it readily available. Make only allegations supported with evidence you can show. Only discuss parenting, not marital issues. We know you're divorcing. Show support for your child's relationship with another parent. Sign releases if asked for evaluator to speak with your supporters. Focus on the child's interest, not your own. Be authentic and genuine. Fake leaves and odor. Show the children are accustomed to playing games as a family. Remember the role of the evaluator. Evaluate, not solving issues. Preparation probably means real change. Psychological evaluation. This mental health professional is a forensic evaluator with the sole intent of creating a psychological profile on an individual person. They will likely offer a diagnosis of most people they evaluate, as this is their purpose. They generally don't offer people a clean bill of health, especially people who are in high conflict custody disputes. If you are generally a sane, sensible, stress-free person, you are no longer that person. You are in a high conflict and stressful situation with a microscope on every aspect of your life. When a judge orders the evaluation, it is usually due to a motion of the opposing party who will pay, or because they find conduct that they believe warrants the evaluation, and the person evaluated usually pays for this. Either way, the only way to prevent this from becoming detrimental is to take self-care seriously, be honest with yourself about your behaviors, and solicit honest feedback from trusted friends and family, and make appropriate changes as soon as possible. Child's counselor. This counselor is hired to counsel a child in your family and report to you about events that occur for the benefit of the child. They usually speak about parenting styles, the child's stressors, and relationship issues. They are not in the role of a forensic evaluator. Parent in counseling. This counselor is hired to counsel you or your spouse, but not both. They usually speak about life choices, events, stresses, and relationship issues. Again, they are not in the role of a forensic evaluator. Family counseling. This counselor is hired to counsel your family as a whole, and usually not individually. Individual sessions may occur, but the goal is not an individual's issues. If an individual's issues require independent counseling, a referral should be made. They usually speak to relationships and household stressors. As before, they are not in the role of a forensic evaluator. Couples relationship counseling. This counselor is hired to counsel two people in a relationship of the same nature and not individually. Individual sessions may occur, but the goal is not an individual's issues. If an individual's issues require independent counseling, a referral should be made. They usually speak to relationships and stressors. As with all the counseling that are aligned with improvement and interacting, they are not in the role of a forensic evaluator. Reunification counseling. This counselor is hired to counsel your child or children and one parent usually, and not individually. Individual sessions may occur, but the goal is not an individual's issues. If an individual's issues require independent counseling, a referral should be made. They are not in the role of a forensic evaluator, but may often be required to report progress to a court. There may be several other roles you might encounter. These are the common roles you are likely to encounter, and the information offered on each should offer you some perspective on how other roles of counselors should be carried out. For clarification, you can always defer to the ethics pages. It is important to know that you are in charge except for court-ordered counselors or evaluations. In court-ordered interactions, ethical rules still apply. Don't tolerate unethical behavior just because you're court-ordered to attend. You can still attend while a complaint about ethics is pending, should the professional choose to continue. The likelihood is that when you tell the professional you believe they are acting unethically and they cannot explain their method, subsequently triggering a complaint, they may quit out of fear. This may not play well in court for you, so if this happens, ensure you have evidence of the counselor's misdeeds. Assume if they are already breaking the rules or are biased that they do have a plan to throw you under the bus. Consider that they have every intention of doing this. I am sure there is a small percentage of interactions that consist of unethical behavior, and most go well, but in the cases when it happens, ignoring it can be very detrimental. There are parents that attempt time after time to get their children help with several different counselors, and the other parent threatens the professional with ethics complaints or lawsuits, and the counselors must recuse themselves from the case. Creating an environment of cooperation, whenever possible, should be your goal, so that if several counselors back out, it becomes clear to the court that you are not the chaos in the situation. If you find yourself in this predicament, you may benefit from personal consulting with me regarding this issue. Jennifer, the mother of my 3 alienated children, was precise in her method of preventing out 3 boys from obtaining counseling while she was alienating them. She communicated to counselors I hired that she demanded they not be seen, as well as hired counselors happily, until the counselors became critical of her. She then fired them. They in turn became witnesses testifying on my behalf. The counselors that did testify for her broke ethical boundaries and are no longer licensed to counsel others. I want you to know now, so you and your children do not end up victims as I experienced. My last bit of advice is to respect the staff receptionist at the offices. They are usually wonderful people. They report to the clinicians. They are great resources for referrals of almost anything. They do the scheduling many times. I could go on. Respect them and your life is easier. This should go without saying, but many times you are walking into an office that your opposing party has recommended, and they have already had an earful about you. And their demeanor is congruent with an earful. Be yourself and be kind. And if that isn't the same thing, get your own counselor. Don't be the problem. This is the end of Module 4, the mental health industry.